Abdullah spoke about, namely either of joining Pakistan,
Yes.
acceding to India, or remaining independent, they gave up the first and the third option.
That's correct.
Have to take place through a process of amending the Indian Constitution itself.
No,
to
for
convert
the
character of 370.
All right, Manoj, now your lordships are again going back on the issue of temporary nature.
Sibal, that concede in the same for the purpose of the
yes,
we're not putting anything in your mouth, not at all. So I don't misunderstand that. Once we a modality through which 370 itself would come to an end.
Well, let's see 370. The reason why it's not an issue is maybe there is a constitutional way of doing this. I'm not addressing that. Nor have they resorted to that constitutional methodology. If they resort to it, it will be tested in a court.
And on the process, you said last time that, first, the Section 92 power was vested in the governor,
yes,
independent of the Council of Ministers.
Step 36, 38.
Right. Step two, the Legislative Assembly is dissolved by the governor under Section 53 without aid and advice.
Yes.
3, the proclamation is issued under Article 356.
Yes.
You said that the object of the proclamation under 356 to eventually restore democracy.
That's right.
And not the decimation of democracy.
Right.
And then finally, we saw the amendment of Article 3 in the presidential notification.
That's right. That's also an executive act.
All these 4 steps, according to you, were constitutionally flawed. There was no provision for these 4 steps because you've essentially taken away the powers of the State Assembly and exercised them under the garb of 356. That's the submission.
That's right. Absolutely, I'm deeply obliged to your lordship. But I just want to read one other.
Only one last thing which I wanted to ask you. You made your point on the process which was followed. They will have to answer it. On the proviso to clause 3 of 370, is there something ultimately that happened in the Constituent Assembly which sheds light on which way the Constituent Assembly was inclined to go?
Yes.
Because we are reading individual speeches. What happens thereafter at the end of this process?
Well,
1957.
The Constitution was adopted in 1957.
Yes.
By the legislature of Jammu and Kashmir. Between 1951 and 1957, they could have determined or terminated the essence of Article 370, abrogated it themselves, and said, we don't want, there's no need for this constitution. We want to be a state, the part of India, like any other state. That is why 370 sub-article 3 referred to the decision of the Constituent Assembly. That decision could have been taken. But my lord asked me the question, well, now that there is no Constituent Assembly, how will this happen? If it were deemed to be a temporary provision. That's what my lord put to me. Right?
So your argument would be really, I mean, if I can put it that way, that the proceedings in the Constituent Assembly of the state of Jammu and Kashmir would indicate a reaffirmation of the arrangement under Article 370 as a long-term arrangement.
That's right.
So that the 3 options that Sheikh Abdullah spoke about, namely either of joining Pakistan,
yes,
acceding to India, or remaining independent, they gave up the first and the third option.
That's correct.
They decide that the ultimate decision was to stay within the dominion of India, but subject to the safeguards of 370.
That's right.
And therefore, according to you, 370 assumes a permanent character, irrespective of the nature of the provision which is envisaged in the Indian Constitution.
And that's what Sheikh Abdullah said in his speech, that look, this relationship...
That still begs one question as to whether it was enough that the Jammu and Kashmir Constituent Assembly proceeded on that basis. Could 370, which was envisaged to be a temporary provision, be converted into a permanent provision merely by the proceedings of the J&K Assembly? Or was there some further act required from the Indian Constitution, either in the form of a constitutional amendment, by virtue of which 370 would cease to have a temporary character but have a permanent character, in implementation of the wishes of the Jammu and Kashmir Constituent Assembly?
Whereas Government of India never expressed a contrary opinion throughout.
But didn't it have to take place through a process of amending the Indian Constitution itself?
No.
To convert the character of 370.
All right. Well, now your lordships are again going back on the issue of temporary nature. That temporary nature is not part of the Article 370. It's not part of it. It's not a part of 370, Madam. In fact, Muzaffar Beg says we didn't even know about it. That's why I want you to read Muzaffar.
Mr. Sibal, there are two ways that we could really lead into this discussion. One, that though placed in Part 21, Article 370 was never intended to be a temporary provision. That's one. That's one layer of reasoning, which is what you're advancing. Two, that though it was temporary, the reason why it was placed in a temporary provision of the Constitution was pending the decision of the Constituent Assembly of Jammu and Kashmir, and therefore it was given the character of a temporary provision, because the views of the Constituent Assembly of J&K were still to be elicited.
Right.
Third, that's the second argument. We accept that for the purpose of hypothesis. The difficulty, of course, which we have to face is this. Assuming that that was why it was placed as a temporary provision, because the views of the J&K Constituent Assembly were still to be elicited. And you also take your point that the J&K Constituent Assembly decided to accede to India and reaffirm the accession to India subject to the safeguards of Article 370. Is that sufficient in itself to convert 370 into an unamendable or untouchable provision?
Let me assume, Malaj, that it is not.
Or was something more required by a parliamentary intervention in India post-independence to convert that which was essentially temporary into a permanent provision?
Let's assume, Malaj, that it is amendable for the sake of argument. Then, Malaj, how is to be amended? The Constitution must provide a solution, no, Malaj? I'll assume, Malaj, for the moment that it is amendable. Then how does the Constitution of India must provide a solution for that?
Once we concede, Mr. Sibal, that concede in the sense for the purpose of the hypothesis. We're not putting anything in your mouth, not at all. So I don't misunderstand that. Once we accept the fact that 370 is subject to the amending power under 368, then equally 370 provides for a modality through which 370 itself would come to an end.
Well, let's see 370 then, Malaj, and see what modality is. That modality can't be to convert a legislative assembly into a constituent assembly by definition through an executive act under 367(1). Then, Malaj, we have to find the modality within the Constitution, not outside it, not vested in an executive power of the Union. That cannot be. So if your Lordship puts to me, and rightly, that something more had to be done under the Constitution of India, we'd like to know what is that something more.
But 370(3) itself specifies the conditions in which the abrogation can take place.
Which is the Constituent Assembly it must be on the recommendation of the Constituent Assembly. So it gives the solution. That is in line with the federated nature of this provision. This is complete federation, whereas we are quasi-federal other states. But these are purely federal Jammu and Kashmir, because the residuary power vests in the state. So if you say that C70 sub-article 3 provides that solution, well, that is provided, certainly, but upon the recommendation of the Constituent Assembly.
And therefore, according to you, the power is completely lost once the J&K Constituent Assembly comes to an end.
Let me even not go that far.